Magazine bans are quietly back in front of the Supreme Court, and most people have no idea it's happening. There's no breaking news banner, no press conference, and no dramatic announcement. But behind the scenes, the legal pressure is building again, and the justices are being asked to confront a question they've sidestepped for years. Do bans on standard capacity magazines actually comply with the Second Amendment, or have lower courts stretched the law beyond what the Constitution allows? This video is for informational purposes only. Laws vary by state and change often, so always verify details through official sources or qualified legal counsel. To understand why this moment matters, you have to look at how magazine bans ended up back at the Supreme Court in the first place. After the court's Bruin decision, the legal standard for gun laws changed. States were no longer allowed to justify restrictions based on public policy arguments or balancing tests. Instead, they were required to show that modern gun laws are consistent with the nation's historical tradition of firearm regulation. That ruling forced lower courts to re-examine magazine bans that had been upheld for years under older standards. In theory, that should have put many of those bans on shaky ground. In practice, something very different happened. Several courts reviewed magazine bans again, but instead of applying Bruin directly, they found ways to keep the restrictions in place. Some courts reclassified magazines as accessories rather than arms. Others argued that capacity limits were historically justified, even though similar limits didn't exist at the founding. And some courts acknowledged Bruin but still upheld bans anyway. That tension is exactly what pushed magazine ban cases back toward the Supreme Court. One of the most closely watched cases comes out of California, where a ban on magazines holding more than 10 rounds has been challenged for years. The case has moved back and forth between courts, been struck down, reinstated, and reviewed again under Bruin. Each time, the legal questions have become harder to ignore. At the heart of these cases is a simple issue. Magazines are not rare or unusual. Tens of millions are owned nationwide. They come standard with many commonly owned firearms, and they're used for lawful purposes like training, home defense, and sport shooting. That creates a direct conflict with the argument states rely on to defend bans. If an item is widely owned and commonly used by ordinary citizens, how can it fall outside constitutional protection? Lower courts have offered different answers to that question, and that disagreement is exactly the kind of split the Supreme Court is supposed to resolve. What makes this moment different from past attempts is timing. The court is now dealing with multiple firearm cases at once, including challenges related to rifles, carry laws, and enforcement standards. Magazine bans are no longer isolated issues. They're tied directly to how the court defines what counts as protected arms under the Second Amendment. Another reason this matters is enforcement. Even while these cases move through the courts, magazine bans remain in effect in several states. That means people can still face criminal charges for possession, even if the law is later struck down. Court challenges don't pause enforcement unless a judge explicitly orders it. That's where confusion sets in. Many people hear that a case is pending and assume the law no longer applies. In reality, nothing changes until the Supreme Court makes a final decision or issues a clear directive. So what exactly is the court being asked to do? The justices aren't being asked to tweak a rule or clarify a minor detail. They're being asked to decide whether magazine bans can survive under the Bruin framework at all. That decision would ripple far beyond one state. If the court rules that standard capacity magazines are protected arms, bans in multiple states could collapse almost immediately. Courts would no longer be able to rely on creative definitions or policy arguments to keep them in place. On the other hand, if the court allows magazine bans to stand, states will likely treat that as permission to expand restrictions further, knowing the highest court isn't stepping in. That's why state officials are watching these cases closely. They understand that a ruling on magazines doesn't just affect magazines, it sets precedent for how far states can go when regulating commonly owned firearm components. Right now, the Supreme Court hasn't announced whether it will take up a major magazine ban case for full review, but the fact that these cases are back on the docket, being refiled and reconsidered, tells us something important. The legal conflict hasn't gone away, and lower courts haven't resolved it. When the Supreme Court repeatedly sends cases back for reconsideration under a new standard, and lower courts keep reaching the same outcomes, the pressure builds. Eventually, the justices have to decide whether to step in or allow the divide to continue. That's where we are now. There's no guarantee when the court will act or which case it may choose, but the groundwork is being laid quietly, without headlines and without much public attention. For people living in states with magazine bans, the practical reality hasn't changed yet. The laws are still enforced. The penalties are still real. and compliance is still required, regardless of ongoing litigation. But legally, the issue is far from settled. This is one of those moments where the absence of news doesn't mean nothing is happening. It means the fight has moved into the background, where long-term decisions are made. Here on 2A Freedom, we track these developments as they unfold, without hype or speculation. When the Supreme Court moves, you'll hear about it here, with clear explanations of what changed and what it actually means. Because when it comes to gun laws, the quiet cases often matter the most. Stay informed, stay aware, and I'll see you in the next update.